One of the things that makes lawyers different from normal people is we lawyers have to be able to reason our way through nasty legal hypotheticals like this one. Here's a criminal law and procedure hypothetical, which is really somewhat stomach-turning, but it's also extremely useful to us as we sharpen our ability at spotting issues and analyzing the facts. Take a look at the call of the question. 1. On what theory or theories of liability might Bill be convicted of rape? Discuss. Well, before we even read the fact pattern, we can take a step back and just reel off the list. Either Bill can be convicted of rape if he was a rapist by actually committing the acts of rape, or as an accomplice or a co-conspirator. That's basically it. Next, we turn to call of the question number 2. Are Art and Bill, or either of them, guilty of the murder of Vicky? If so, is the offense going to be a first or second degree murder? Discuss. Well, we know the elements of homicide, and we also know the difference between traditional common law murder, now called second degree murder, and the modern statutory creation of first degree murder. Then, question 3. Is Bill's statement to the police, or any part of it, admissible at a joint trial of Bill and Art if neither testifies? Assume all proper objections are made. Discuss. This is a classic criminal procedure question, which also is an evidence question, and the exact same legal issue could just as easily be framed in an evidence question as in a criminal procedure question. So, without even reading the fact pattern, where we have two defendants being tried criminally in the same case, and we have an incriminating statement made by one, the other defendant will have a valid Sixth Amendment objection based on the right to confront if the statement is sought to be used against the defendants. So, and incidentally, if you're interested in legal scholarship, something you may actually not be that interested in preparing for the exam, this right to confront has been recently addressed by the Supreme Court, and although this current Supreme Court has got a reputation for being hostile to criminal defendants, its work on the Confrontation Clause has actually expanded the rights of criminal defendants based on the Sixth Amendment to the U.S. Constitution. So, we've got a reasonable idea about how we're going to answer question 3 before we even read the fact pattern. In order to get a better idea about how to answer the other questions, we've got to look at the facts. So, let's go to the top, and here we see another well-written, intelligent fact pattern. In paragraph 1, we meet Art and Bill and Vicky, and the two of them agree to kidnap Vicky. All right, well, stop right there. At the moment that they enter into that agreement, the crime of conspiracy has been completed, and they plan to make a ransom demand on her parents. Remember, the act of ransoming a kidnapped victim is not an element of kidnapping. All you've got to do is unlawfully detain somebody and then move them, and that's basically good enough to establish kidnapping. We learn in paragraph 1 that Art had been convicted of a forcible sexual offense in the past, and so Bill insists up front that Art agree that no harm will be inflicted on Vicky. Art assures Bill that he would not harm her. Well, let's just stop right there. Here we've got a completed conspiracy, and we've got one of the two co-conspirators worried about the criminal propensities of his colleague. Now, any violent sexual crime committed by this guy is going to be foreseeable to the other. Moving on to paragraph 2, here Art and Bill in fact do kidnap Vicky. They lock her in a room in Art's house, and they communicate a ransom demand to the parents. Well, realize that the kidnapping was completed before the ransom demand was communicated, but I don't think anybody can disagree with the fact that the crime of kidnapping has been committed. The parents call the police, and the police can't find and rescue Vicky. We turn to paragraph 3. Here's the disgusting paragraph. Several days after the kidnapping, Art rapes Vicky. Now Vicky is despondent over being confined, and she is mortified by the rape. Vicky commits suicide only hours after the rape. Well, let's just stop right there. With regard to the rape, we're going to be able to determine that both defendants are guilty. The one that committed the rape will be guilty just on the basis of having committed the rape. The other will be guilty as an accomplice, but not as a co-conspirator, because the conspiracy specifically excluded sex crimes from the deal. And a crime that is committed outside of a conspiracy is one that the co-conspirators will not be held liable for. But that's no great reason to celebrate on the part of Bill, because Bill is going to be convicted as an accomplice rather than as a direct principal or as a co-conspirator. So, Vicky has killed herself hours after the rape. Bill wasn't present, and he had no knowledge of the rape or suicide until Art told him about it. And after Art reports this information and also volunteers the helpful fact that he's about to dispose of the body, then Bill immediately goes to the police. He turns himself in, he makes a full confession, and the examiners helpfully give us letters A, B, and C about the details of the confession. Then police obviously arrest Bill. They go to Art's home, they arrest Art, they find Vicky's body, and then we get the calls of the question again. A fairly straightforward, if unappealing, set of facts. Now, let's take a look at the analytical outline that I suggest and the way to think about how to answer this question. And remember, a very similar fact pattern to this could well appear on either the MBE or on the essays. This question in particular is another question with a lot of generic elements. Stuff just like this is tested very commonly. So let's focus specifically on the people versus Bill for rape. Their theories of liability include conspiracy and accomplice liability. We know that their conspiracy theory is going to fail because the agreement between Bill and Art specifically excluded this idea of sexual battery or other violence directed at the victim. So Bill isn't liable as a co-conspirator because their agreement specifically excluded this conduct. However, Bill is going to be guilty as an accomplice because the same facts that helped Bill escape liability from conspiracy, his knowledge of Art's propensity to commit violent sexual acts and Bill's desire to avoid that happening, those facts make it foreseeable to Bill that Art would commit this crime. And so as an accomplice, Bill faces liability for rape as an accomplice. Now, we wouldn't stop there. We are given specific defenses that would be raised by Bill. All of them are lousy, but the difference between a good essay answer and a poor essay answer often is the degree of specificity with regard to the analysis. So let's acknowledge Bill's defenses. Number one, he didn't rape the victim. Sadly for him, that isn't a good enough defense for him to escape liability, because as an accomplice, he's liable for all foreseeable crimes. Bill also would assert that he didn't even want this victim harmed, and he expressly wanted Art to leave this woman alone after kidnapping her. Well, that's enough to give him a defense to conspiracy, but it isn't good enough to give him a defense as an accomplice. Also, Bill's final act that he can use in a defense is that he went to the police, and that arguably could be a withdrawal from any conspiracy. However, all of the crimes had been completed at that point other than disposing of the victim's body. So all three of Bill's claims to escape liability, all of his defenses, are invalid. So the bottom line is the people's case against Bill for rape is going to prevail. He's guilty of that charge. So now we go to the second criminal charge, murder, and here the prosecution is going after both Art and Bill. Well, what is the crime of homicide? It's the intentional taking of a human life with malice. Neither one of these defendants killed this victim. So they can't be convicted of homicide based on the most traditional way of doing it, pointing a finger at the defendant and saying, "You did it." But here we have a victim who takes her own life during the course of a felony. And so The felony murder rule would apply here. And by the way, the most traditional common law felony murder would apply just as well as the modern statutes, because the crime of kidnapping and the crime of rape both are traditionally known as violent felonies, and any death that results is a felony murder as a result of that fact. Now, we have to address each felony separately. This woman has been the victim of two different violent felonies. First, kidnapping. We know that at the time of the rape, she'd been confined for several days already. That means that the crime of kidnapping was ongoing. It had not been completed, although obviously the prima facie elements had been completed, but the crime itself was still in progress. So if her death occurs during a kidnapping, the defendants are likely to be guilty. Is it foreseeable that a kidnapped victim would commit suicide? Well, probably yes, but particularly a kidnapped victim who has already been raped once. It's very foreseeable that a rape victim who has been kidnapped would be subject to repeated sexual assaults. Under the totality of the circumstances, it seems extremely foreseeable that such a victim would take her own life. And therefore, the guilt of both Art and Bill for murder based on felony murder and the kidnapping is likely. They're both guilty of felony murder. Now, but we consider the other felony, the rape. The suicide happened several hours after the rape. It is likely that the defense could argue with some degree of success that the rape had been completed. She was suffering from the trauma of the rape, and she was still being kidnapped. Personally, I think it more likely that the felony murder rule conviction would be based on the kidnapping, not the rape, but I don't think anybody could be judged, quote-unquote, wrong to find both of them guilty of felony murder, both for the kidnapping and for the rape. In either event, regardless of how much we split hairs, the correct answer to this question is Bill and Art are guilty of murder based on the felony murder rule. And almost certainly under modern jurisdictions, this would be considered a first-degree murder offense. We turn finally to the evidence issue, which also is a criminal procedure issue, the admissibility of Bill's statement. Remember what happened from the facts. When Art told Bill about the rape and the suicide, Bill turns to the law enforcement. He's arrested, and he makes this highly incriminating statement, which every element of which is true. So, as we consider it from an evidence perspective, one who proffers an item of evidence has to establish its logical and legal relevance. That's easy to do in this case because the statement clearly is evidence of the guilt of both defendants. Here, the Fifth Amendment could be raised by Bill because the statement is being offered against Bill. Clearly, Bill made this statement voluntarily. It was not extracted in violation of Miranda. It's a voluntary confession by Bill. And as a result of that, a Fifth Amendment objection based on compelled testimony would fail, and the statement is admissible against Bill. With regard to Art really doesn't have standing to contest the admissibility of Bill's statement on the basis of the Fifth Amendment, because the statement came from Bill, not from Art. But Art does have a very convincing reason to object to this evidence based on the Sixth Amendment. Art has a right to confront Bill, and Bill is not choosing to testify, so the statement can't be used against Art. Since the two of them are being tried together, the statement would have to be redacted in order to avoid any mention of Art. And that might make the statement somewhat meaningless in that trial. However, it would also be a justification for either trying them separately or trying them together in front of separate juries. It would make the statement more easily admissible, although, as I look at the facts, it's likely these two could be convicted of all of the charges, even if the statement is not admitted against them. But it's interesting to have a look at this pattern, not only because it is testing issues in a very interesting and somewhat counterintuitive fashion, but it also shows us where the law of criminal procedure touches the law of evidence.